Jobs Act stands for the, quote, Jumpstart Our Business Startups Act, close quote. Like many a legislative title designed to support a catchy acronym, it's inaccurate in every particular. The legislation isn't limited to startups. It covers trading companies with as many as 2,000 public investors. And it isn't about jobs. It's about the cost of capital for smaller firms. A firm could produce no jobs at all and still be covered. Political actors care about jobs because people vote. But from the economic standpoint, the goal is efficient production rather than production that requires a lot of labor. The legislation was enacted last spring with bipartisan support, a real rarity these days. It responds to the fact that existing regulation imposes many fixed costs on public firms. They have to file registration statements with the SEC in order to raise capital. And then, once they're trading, they have to produce quarterly and annual reports. Their financial statements have to be audited in ways that comply with federal standards. The larger the firm, the more these steps cost. But there are substantial fixed or unavoidable costs, no matter how small the firm. Every document must cover prescribed subjects. Printing costs alone can be substantial, and the firm has to pay for hundreds or thousands of hours' work by accountants and lawyers. In the mid-1990s, students of the subject estimated that in order to raise $1 of capital, small firms had to pay about 20 cents for federally required activities, while the largest firms had access to methods such as shelf registration that cost less than 1 cent per dollar raised. Large IPOs could be conducted for 10 cents on the dollar or less. That's a huge disadvantage for smaller firms, and the disadvantage continued through the years of periodic reporting that follows initial registration. The Sarbanes-Oxley Act, enacted a decade ago, raised those costs. In response to revelations that accounting firms provided little value and failed to catch flagrant frauds, Congress required, are you ready for this? Congress required that firms purchase additional accounting services. The act doubled or tripled outlays for accounting, which again disfavored smaller firms. The original estimate for the annual cost of complying with one part of the statute, the notorious Section 404, was given by the SEC at $34,000 per firm and by an accounting board at $91,000 a firm. The actual cost turned out to be in the millions. The cost has been whittled down over time, but again it acts as a regressive tax, hitting smaller firms harder per dollar of revenue. The Jobs Act promises some relief. Whether it delivers and whether the benefits are worth the other effects of the changes is the subject of today's panel. The statute has several parts, and the panel won't cover them all, but it's worth a minute or two to tick off a few of the most important. One, the law increases the number of shareholders a company may have before being required to become a public reporting company that must file periodic reports and satisfy other obligations under the Securities Exchange Act of 1934 and the SEC's regulations. Previously, this happened once a company's assets reached 10 million and it had 500 shareholders of record. The new act changes this so that the threshold is reached only if the company has more than 500 unaccredited shareholders or 2,000 shareholders total. The act provides a new exemption from the requirement to register public offerings with the SEC. It authorizes internet funding portals, sometimes called crowdfunding. One condition of the exemption, though, is new regulation of the year. It sets up a yearly aggregate limit on the amount each person must invest, and that turns out to be a fairly complicated limit. The act relieves some companies, which it calls emerging growth companies, from regulatory and disclosure requirements when they go public, and for 5 years afterward. The most significant of those is Section 404, the Sarbanes-Oxley Act. Previously, new issuers had only a 2-year phasing. The act rescinds the former ban on general solicitation and advertising, in particular kinds of private placements of securities. and it raises the limit for securities offerings exempted under Regulation A from $5 million to $50 million. I mean, there are a bunch of other things, and we may discuss some of them, and I bet that we won't discuss all of those I have listed, but that's the general kind of change that we will be discussing today. Now for a brief introduction of the panel. I'm going to introduce all of them at once. There are longer versions of their bios in the program. I'll introduce them in the order in which they will speak. Each will give a brief presentation. An exchange among the speakers will follow, and then I'll open it up to discussion from the floor. Robert Miller is a professor of law at the University of Iowa College of Law. Before entering academia, he was an associate at Wachtell, Lipton, Rosen, and Katz in New York. His scholarship concerns corporate and securities law, the economic analysis of law, and the philosophy of law. Joanne Madero is a managing director at BlackRock with responsibilities for government relations and public policy. Ms. Madero's service with BlackRock and its predecessor, Barclays Global Investors, dates to 1996. Before that, she was a partner with Orrick, Harrington, and Sutcliffe, specializing in derivatives and market regulation. She also has served as general counsel of the Commodity Futures Trading Commission. Robert Thompson is the Weidenbruch Professor of Business Law at Georgetown, where he specializes in, well, business law, corporate and securities law in particular. He's produced casebooks in corporations and on mergers, treatises on close corporations and limited liability companies, and more than 50 articles. Joseph Kaufman is a partner at Simpson Thacher, specializing in corporate and securities law. In 2011, the National Law Journal dubbed him one of the 3 most influential lawyers in the finance and capital markets category. His law degree is from the University of Chicago. I mentioned this in a bit of hometown favoritism. And our final speaker is Daniel Gallagher, who has been a commissioner of the Securities and Exchange Commission since last year. For 5 years before that, he had been counsel to 2 other commissioners and a senior member of the Division of Trading and Markets. Commissioner Gallagher began his career in private practice, advising clients on broker-dealer regulatory issues, and has had several returns to the private sector, interwoven with stints at the agency. Professor Miller.
So Title III of the Jobs Act is entitled Crowdfunding, and if you're like me, which is to say you're over 40 years old, you probably never heard this word except in connection with the Jobs Act. Maybe the first time you heard it was when Judge Easterbrook said it a minute ago. So what is crowdfunding? Crowdfunding is raising a lot of money on the internet by taking small amounts from a very large number of people. And even prior to the Jobs Act, it existed in certain forms. So if you go on the internet to a site called Kickstarter, Kickstarter is probably the largest existing crowdfunder. On Kickstarter, people who create projects known as creators in Kickstarter lingo find people known as backers who want to provide them money. And the projects might be artistic or theatrical or musical or the invention of video games, or the invention of certain kinds of products, usually high-tech products. So the featured product on Kickstarter this morning is something called Puzzlebox Orbit. And Puzzlebox Orbit is developing a mind-controlled toy helicopter. I kid you not. It comes with a headset that you put on that reads your brain waves, which it talks to a laptop computer, which then uses infrared rays to control a toy helicopter. And if you concentrate hard enough, the helicopter lifts up and you can control where it flies around the room. And I know that this works because there's a video on Kickstarter actually demonstrating a working prototype. And if you like this idea, you approve of mind-controlled helicopters, you can help out Puzzlebox Orbit by giving them some money. They'll take anything from $1 onwards. If you give them $10, they'll make sure you get thanked in some website of theirs. If you give them a little more, they'll send you a T-shirt which has a stenciled mind-controlled helicopter on it. It's very becoming. If you send them $89, they'll send you the simplest version of their mind-controlled helicopter when it comes out in commercial production, and they have an estimated date for that. Send them $249, and then you get the deluxe version of the mind-controlled helicopter, which comes with all the paraphernalia, also when it finally comes out in commercial production. Now, like me, again, if you're over 40 years old, this probably sounds ridiculous to you. Who would pay for this? The answer is Puzzlebox Orbit wanted $10,000 for this project, and already they've received offers to give them $14,000 for this project. They are fully funded. And Kickstarter, in the couple of years that it has existed, has raised more than $350 million from more than 2.5 million people for 30,000 projects. This works very well, apparently. Now, the one thing you can't get on Kickstarter, which you get are rewards in their lingo, the one thing you can't get as a reward is an interest in the company. Okay? You can't get stocks, you can't get any other kind of securities. And the reason for that is, prior to the Jobs Act, Section 5 of the Securities Act basically prohibited you from doing this. Section 5 says, as most of you know, that it is illegal to sell securities in interstate commerce unless you either register the sale with the Securities and Exchange Commission or else qualify for one of the many exemptions. And as Judge Easterbrook was just saying, registering with the Securities and Exchange Commission is very expensive. You have to prepare a prospectus. It has to include audited financial statements for the last few years. That's a very, very expensive proposition. Clearly takes several $1 million worth of accounting and legal fees. And if you're like Puzzlebox Orbit and you only want $10,000, this is obviously a non-starter for you. So you might start asking about the exemptions from the registration requirement, and there are many different ones, and they're very confusing and complex, and they overlap in various confusing ways. So the first thing you would need to do would be hire a securities lawyer to tell you about them, and he's going to end up charging you more than $10,000 too, probably. And even worse, when you finally sort out what all the exemptions mean, the basic theme that runs through all of them is that if you wanted to engage in a general solicitation, going out to the world generally and saying, please invest in my mind-controlled helicopter, you had to prepare not a prospectus, but something that looks a lot like a prospectus, an offering circular or a private placement memorandum, and that got really expensive too. So if you want to build mind-controlled helicopters and you need $10,000 to do it, you are not going to be able to use one of these exemptions either, realistically speaking. Title III of the Jobs Act changes all that. The basic concept in Title III is that we're going to create a new kind of financial intermediary called a funding portal. The funding portal is the investing analog of Kickstarter. On the funding portal, people who want to sell securities to the public will first convince the funding portal to list them as an issuer. On the funding portal, they'll provide certain information about the securities they want to sell. And potential investors will come and look at the funding portal, look at the vast number of opportunities they will have, and will choose to invest any amount, probably with something like a $100 minimum. That would be up to the funding portal. And that you can use your credit card to sign up. If the target funding that the issuer wants is reached, then everybody's credit cards are charged and the deal closes. If the funding target is never reached, then nobody is charged and the deal fails. Now, the statute itself provides certain limits on this. If you are on the issuer side, you can only raise up to $1 million every 12 months doing this. So you can't sell loads and loads of securities, only $1 million every 12 months. If you're on the investor side, there are limits as well. They're somewhat complicated, but the basic idea is that you can only invest 5, or if you're wealthier, 10% of your annual income in all crowdfunding issues together, not per issue, but total crowdfunding issues. All of your crowdfunding investments together can't exceed 5, or if you're wealthier, 10% of your annual income. Well, what kind of information are you going to get when you look on the crowdfunding site and want to invest? Well, we don't know for sure, but the statute says that if the offering is under $100,000, which is by far going to most likely be where most of the offers are, the required disclosure will be tax returns from the issuer and some kind of certification from its chief financial officer saying, these are our financial statements and I certify they are correct. For offers between $100,000 and $500,000, you're going to get financial statements that are reviewed by an accountant, but not audited. And exactly what reviewed means, the commission is going to have to specify by rule. And for offers over 500 but less than $1 million, you're going to get audited financial statements. In addition, the statute authorizes the SEC, by implementing regulations, to require whatever other disclosure it thinks is appropriate, and we don't know what that is yet. Those regulations are due out in January. So the hope is, if you think this is a good idea, that the SEC will not add up so much new disclosure that the disclosure required for crowdfunding looks like it would go into an offering circular or a private placement memo, because if it does that, you've just basically closed down crowdfunding as a viable funding tool for small businesses. So what's the danger here? Well, the danger here goes under the name of crowd frauding, namely securities fraud on the internet, and you can imagine that the SEC is deeply worried about that. Now, of course, the SEC is always worried about fraud. They have institutional incentives not only to be worried about fraud, but to be over-worried about fraud. When a large securities fraud occurs, the SEC is blamed, fairly or unfairly, usually unfairly, in my opinion. And people from the SEC get hauled before Congress, where very self-righteous congressmen tell them what a terrible job they did implementing laws that the Congress people have never read and don't understand. And if you're at work for the SEC, you don't want that to happen. So you have very strong incentives to make sure fraud doesn't occur, and in fact you have incentives to even put in over-restrictive laws to make sure fraud doesn't occur, because the harm from that is there's lots of good businesses who can't access the capital markets, but those people are largely invisible. They're not like fraud victims who are beating down your door and complaining to your congressman. So how big a problem will fraud be in the crowdfunding market? I'm here to tell you today it's not going to be a big problem at all. And there are several reasons for this. The first is there's all the support in the world in economic theory to think that this is not going to be a large problem. Why? Because what we have in crowdfunding is one person, the crowdfunding portal, who makes a market between the potential investors and the potential issuers. The way the crowdfunding portal makes money is it takes a small cut of each deal. It therefore has the strongest incentive to make this market as large as possible, so it makes as much money as possible. It therefore has the strongest incentives to stamp out fraud. Why? Because if there's a lot of fraud on a crowdfunding portal, its whole market disappears. Investors don't want to come to that market because they know that all the fraudsters are on that market, and issuers don't want to come to that market because they don't want to be associated with the fraudsters either. So you should expect that the crowdfunding portals themselves will do quite a lot to prevent fraud. That's not just economic theory. It turns out that there is already a crowdfunding portal that's not quite in operation yet, because it would be illegal for it to be in operation until those implementing regulations come out. But you can look at a site called WeFunder.com. WeFunder is already in beta, which means that it is taking issuers who want to issue securities, and it is taking backers or investors who want to invest in them. And the deals won't close until it becomes legal for the deals to close in hopefully sometime early in 2013. Are people signing up for this? Yes, actually, they are. Backers on WeFunder, more than 10,000 people, have already signed up to invest more than $28 million in 150 businesses. How is WeFunder preventing fraud? Well, they're doing some very traditional things, like they're going out and doing background checks on the people who want to list their securities there. And they're doing some kind of very obvious sort of market checks things as well. So for example, WeFunder is taking its fee in part in equity in every person who closes a deal on WeFunder. So WeFunder invests alongside the investors on exactly the same terms they get, which of course gives them good incentives to prevent fraud. And they're doing things like, if you want to fund on WeFunder, you have to have at least one accredited investor already signed up. This means that some sophisticated person has probably looked over the deal fairly carefully, and in addition, the investors on WeFunder buy in at the same valuation that the accreditor investor got, so you get some protection on the valuation of the securities. Even more important than that, WeFunder requires that if you want to raise money on WeFunder, you link your securities offering to your Facebook page. Now, why is that important? Suppose you live in a really small town. Is it easy to get away with fraud there? No, because if you commit fraud, everybody knows about it, and then you're stigmatized, and bad things happen to you. Just ask David Petraeus about that kind of stigma. On WeFunder, if you commit fraud on WeFunder, your whole social network is going to know about it. Your future employers will know about it when they check your Facebook page. That cute girl you met in the bar is going to know about it when you and she friend each other on Facebook. Right? Your entire life on Facebook, which occurs in public, is now linked to your securities offering. Those of us who are over 40 and have thought that it's ridiculous that our teenage children live their whole lives in public are right about that in many respects. But there's one good thing about living your life in public. It's very hard to commit securities fraud doing it. And if the SEC hasn't figured this out yet, there's a reason for that. They're all over 40. Thank you.
Well, I thought I would talk a little bit about Title II of the Jobs Act, which is called the Access to Capital for Job Creators. And what it does is it mandates the SEC to make rules to lift the prohibition on general solicitation and advertising under the private placement rules. Some of you know as 506 or Reg D. This is one of the exceptions to registration under Section 5. So long as the purchasers are accredited investors. So basically, now it would be okay to offer so long as the sale only occurs to accredited investors. What the statute said, Congress sometimes imposes deadlines on agencies, asks the SEC to produce final rules 90 days after the passage of the statute, which meant that the rule should have been final by July 4th. Now, I don't think anybody realistically expected that the SEC would move that quickly, but without any deadline at all, they may not have moved at all because this is a very big cultural shift for the SEC. Anyway, the deadline was missed, but we do have a proposed rule that came out on August 29th, I believe, and that proposal is still out there pending. Now, why is this such a significant change? Well, the SEC and FINRA, or its predecessor, NASD, which is the self-regulatory organization for broker-dealers, has taken over the years a very expansive view on what is a solicitation and what is advertising. So, for example, if a broker-dealer sends the same letter to 10 or more persons saying, gee, you know, we think Microsoft is a good deal, that's advertising. And a solicitation could be something as simple as an issuer being on some kind of media talk show program who mentions the name of their company or, closer to my world, the name of their fund and what its strategy is. And that would be considered to be a solicitation. And this is when your compliance people then come to you and say, guess what, you cannot make any offers or sales of your fund for a cooling off period. And it's always a very difficult conversation with your business people because they keep saying, but that makes no sense. And it doesn't. And that's one reason why there was a big effort to change this rule. Because really the only harm that can occur, right, is if you actually purchase something. So the fact that you are offered something or you see an advertisement about something, it should not be any harm. But traditionally, the SEC has wanted to regulate offers and sale, as well as sales. The statute basically tells them that's what they're supposed to be doing. Now, for the funds industry, of which I'm a part, what these broad interpretations of solicitation and advertising do also prevents funds, hedge funds, private equity funds, let's think about Bain Capital, actually responding to press inquiries or even correcting misleading information that's out there in the media. Otherwise, you're afraid you're going to trip over either the solicitation or advertising rules. So some of the popular view of private funds, hedge funds, private equity funds is driven from the fact that they actually can't be as transparent as they would like. Now, the other thing is that, and I think that helped provide some support for the changes in Reg D that we saw in the Jobs Act, is that there's a number of commentators over the years that have simply said that the SEC should be using its limited resources on policing purchases and not offers. And again, because that's where the harm can occur. Now, it's important to understand this is a big cultural shift for the SEC. I don't think anybody else mentioned it, but the Jobs Act moved very rapidly. It had been kind of kicking around the House for a while, and then President Obama, in his State of the Union address, endorsed it. It collected a few more pieces soon after that, but actually went and was passed in about a 6-week time frame. The SEC did not, at least in any visible way, participate in the legislative effort in the House. But when it got to the Senate and it looked like it was going to pass, they got very engaged and opposed it, or at least significant parts of it, including this particular change. And the interesting thing is that there's nothing in the statute that said that they couldn't have made some of these changes themselves. And in fact, there was a petition from the funds industry asking them to make this particular change that had been pending at the SEC. But they were unwilling to, culturally, to make that move, to make that big shift. So Congress told them that they needed to on a bipartisan basis. Now, it may surprise you, given the cultural shift here, that the SEC's rule proposal tracks the statute. And pretty much what I think, anyway, to be the legislative intent. So you would think that's fine, and this is really good news, and the agency's taking appropriate direction, which they are. But there's actually a lot of controversy coming up on this rule proposal, and it's coming from consumer and investor protection groups, some of the state securities administrators, and even, believe it or not, one financial services trade group, the Investment Company Institute, because they oppose the rule as proposed, and because they are concerned about investor protection. They think that lifting the ban needs to have further conditions in order to protect people who receive offers. They are trying to, in my view, hamstring issuers in how they determine whether or not an investor is accredited. There are established practices today, and they're seeking to impose and asking the SEC to impose more constraints on how one confirms that you have an accredited investor. They would like to see a change in the accredited investor rules, even though the SEC has recently reviewed those under Dodd-Frank and has made changes. They would like to see more. And the other subtext in all of this that comes out is that this fear that less scrupulous issuers will advertise and solicit potential investors and then not follow through with the rule that says you may only sell to accredited investors. Well, that happens today because if you're going to violate the law, you're going to violate the law. So more rules here I don't think is going to change any of that. Now, what's motivating investor protection groups, I think, is what I would consider to be kind of the usual paternalistic motivations, that they don't think that accredited investors can manage on their own. They are worried about investors who are not eligible to purchase being confused. And the ICI's objections, I think, are mostly motivated by competitive concerns because registered investment companies, mutual funds, which is their constituency, are registered and are subject to a lot of rules, just like any other issuer, and a lot of costs. And my conversations with them have always gone along lines of, well, why don't you try to see what you can get to do, get your costs reduced rather than imposing costs on other parts of the industry. Now, in my view, both sets of people who are opposed to the rule as proposed are not actually considering the likely behavior of the issuer. You're not going to see people going out and running Super Bowl ads saying, buy my hedge fund, because what you're trying to do is gather leads for investors who could actually purchase. And so we think what you're going to see, if you see any general advertising at all, will be very targeted in very trade-specific publications where you're most likely to, where have you spent your money, you're most likely to get something that's useful. And what this will do is will allow people to be more responsive and be more able to explain their businesses without running a risk that they somehow have made, a solicitation or an advertisement where their counsel is going to tell them that they can't engage in a private placement for a period of time. Now, it's important to keep in mind that this part of the Jobs Act does nothing about the anti-fraud provisions, and so if there is fraud in the sale of the securities, all those remedies, including the SEC's enforcement capabilities, are still there. So what we are in the industry hoping for is that the SEC will move to finalize its regulations in pretty much the form as proposed. Thank you.
The Jobs Act is the biggest deregulatory statute in the history of American securities regulation. That's not a high barrier to cross. But nevertheless, as you've already heard, it's something of a cultural change that Joanne has talked about. There are two entirely new exemptions: crowdfunding that Robert's already told you about, and another one that will come down the aisle a little bit later called Regulation A+ for under $5 million. That's two new exemptions in which the history doesn't. We don't have those very often. We have two new ones in 1 year. Plus 506, the private placement exemption, which is the most important exemption, is going to grow dramatically because of the changes that Joanne has talked about. I want to talk about, so those are three on the 33 Act. I want to talk about the two big changes on the 34 Act. One that I'll just mention is what Judge Easterbrook began with, the on-ramp. This is letting emerging growth companies have an ease their way onto publicness obligations by letting them exempt the biggest, most expensive ones for the first 5 years. This will be a dramatic change for the 34 Act reporting companies. The other change also mentioned by Frank was the 12G threshold that says, when do you have to take on publicness obligations? You have to do it, as he said, if you have, used to be 500 shareholders, now it is 2,000 shareholders. Now, a four-fold increase in the threshold before you have to undertake the obligations of being a reporting company would seem like a large deregulatory change. And had it been in effect a year ago, Facebook may well not have gone public. Think of the pain that would have been saved if that had occurred. But the change is not as big as it seems, because there are three ways into the 34 Act obligations. There are three thresholds, any one of which will trigger your obligation to spend all the money that Frank talked about. The first is, if you make a registered public offering, you have to satisfy reporting obligations as a public company. Second, if you're listed on the stock exchange, you have to satisfy reporting obligations. Third, if you used to be 500 shareholders, $10 million in assets, now 2,000 shareholders, $10 million in assets, you have to satisfy the 34 Act. Any one takes you into the Act, so that, flipping that, you can only stay in the deregulated space if you avoid all three. Now, what does that mean in economic terms? It means that the only time you can use this new space from the Jobs Act is if you can raise needed capital without going public. And if you can get the liquidity for your shareholders without going to the stock exchange. And if you stay under now 2,000 shareholders. Now, who can satisfy all three? Cargill, Koch Industries, but once you get beyond those two, there aren't very many recognizable names. So the point is that most companies can't give up the capital raising avenue and the liquidity avenue that publicness brings. But that may change. Why? Many of you probably know that venture capital and private equity provides much larger share of capital raising than it did a generation ago. So we are finding 506 is now bigger than the amount raised in private offerings, bigger than the amount raised in IPOs. So the calculus has changed on capital raising. On liquidity for your shareholders, there are things like second market and shares post. Have you dealt with that at all? Anybody? Second market and shares post are platforms that provide a way to trade stock outside of an exchange. Facebook traded in millions, billions of dollars before it went public. So this is a dramatic change. This means it is possible that as we go forward, the next Facebook, who doesn't want to share information with its competitors, who can get its capital from venture or private equity, who can get liquidity from shares post or second market, will not go public. And so we will have many more companies occupying this non-34 Act space. And there's another way out. The 12G threshold is phrased as 2,000 record shareholders. Now, if you're older than 40, you have to be older than 70 to remember why we have record shareholders. It dates from 1964. That was the criteria, 500 record shareholders. Well, immediately, within 5 years, we had the back office crisis on Wall Street, and we jettisoned practically record shareholders, and we went to street name. And so what it means is, once you go public, no one uses record owners. Everyone's in street name, and that keeps the number of record owners down. What it means, 12G will not be a binding constraint. So what we're looking at is the possibility, not today, but in the foreseeable future, that because you can raise capital from venture and private, because you can get liquidity from second market and shares post, and because you can avoid 2,000 by only counting record shareholders, no one will have to come under the 34 Act. That would be an amazing change. Now, one last point that I want to tie into the discussion of 506. Lifting the ban on general solicitation, which will come soon, will increase the number of investors who get their shares via a private placement without the disclosure of a registered public offering. So there'll be a lot more shares out there for which there has not been disclosure in the first transfer from issuer to investor. Those investors, employees, others, will then want to resell their shares because we all have change in our life and we need liquidity from time to time. When they resell, they will then come within this deregulated 34 Act space. There will be no 34 Act disclosure for those people. In this sense, this is a return to pre-1964, when we had a large number of companies in which there was regular secondary trading of their shares and there was no disclosure. 64 changed that. We are going back to that point. Let me just paint one picture of putting the two together. Given that 506 is going to grow and is already bigger than IPOs, private placement for raising capital, and this is to accredited investors. So when you raise money to accredited investors, there is no mandated disclosure, there is no limit on the amount of money you can raise, there's no limit on sophistication, there is no anti-fraud provision. 12A2 doesn't apply. You get to raise capital in 506 to accredited investors with practically no regulation. That's the initial sale. Then, when your sellers get ready to resell their shares, because you're under 2,000 and because you haven't registered on a stock exchange and listed on a stock exchange and you haven't done an IPO, the resale occurs without any periodic 10K, 10Q disclosure for the resale market. The only cost is Rule 144 that I taught just before I came over here that is incomprehensible to understand, but it basically requires you to hold your shares for 1 year if you're a non-reporting company before you sell. Absent that limitation, this is what we have. You have the initial issuance pursuant to 506 to accredited investors with no regulation, and then you have the resale with no regulation. Deregulatory securities nirvana has arrived.
Thanks. I'm going to talk about Title I of the Jobs Act, which is mentioned the IPO on-ramp, although based on the prior speakers, I'm not sure why anybody would want to actually do an IPO with all the exceptions there. Just a cautionary tale to any of you students out there, pay attention in class because you never know when 20 years from now you'll be giving a presentation on securities regulation with your securities regulation professor sitting right next to you. The good news is what I'm going to talk about is all new regulation, so if I forgot any of the things I learned, they're different. So in addition to all the wonderful things that the Jobs Act does with respect to private offerings and enabling companies to stay private, there are some substantial provisions that do change the landscape with respect to actually conducting IPOs. To the extent that you qualify as an emerging growth company, there are different tests, but the basic standard is if you have less than $1 billion of revenue in your last completed fiscal year, you're likely going to qualify as an emerging growth company and be able to access some very helpful provisions in terms of being able to decide whether or not to proceed with an IPO and then to get the IPO done. Obviously, that $1 billion threshold is pretty high. It's estimated that probably, certainly the vast majority, probably close to 90% of eligible companies to do an IPO would qualify under that standard, but there are some, such as Facebook and others, that would still stay above. May talk a little bit at the end as to whether or not some of these provisions should be extended to the larger companies. So if you're an emerging growth company, what are the provisions of the Jobs Act that help you out in terms of an IPO process? Well, there really are four that I'll talk about. One is testing the waters. The second is a confidential SEC review. The third is reduced disclosure in your IPO prospectus. And then finally, ease on limits on analyst reports for securities analysts that are affiliated with the underwriters in the IPO. One of the great golden rules of the Securities Act of 1933 was the gun jumping provision that said that you could not engage in any communications with respect to your IPO before a registration statement was on file with the SEC. And then after you have it on file, there are limited communications, certainly with respect to written communications, until you actually launch a roadshow and have a preliminary prospectus with a price range that's included. Well, the Jobs Act provisions really throw a lot of that out of the window and says that if you are an emerging growth company, before you go on file, you can actually have communications with certain institutional investors and talk about your company and actually have a conversation about valuation and whether or not that investor might be interested in buying your IPO. And the goal being that maybe to get more information about whether investors might be receptive to your IPO will give a better indication as to whether or not this might be an appropriate time to move forward with the cost and expense of going public. In theory, that's a terrific provision. In practice so far, now this is Title I, unlike some of the other provisions of the Jobs Act, Title I is in effect now, and some companies have begun to utilize it. But there are still concerns in practice about how much testing the waters will actually get done. The SEC has requested in connection with any filing that if you do provide any written materials in a testing the waters communication, they'd like to review it. There's always the potential for liability on those materials. And frankly, the feedback so far from institutional investors are they're a little bit tired of engaging in these theoretical discussions, and they really only want to talk to a company when it's time to do a roadshow and actually get down to business as to how much this stock is actually valued at. But in theory, if a company is on the fence debating whether or not to move forward, that's certainly a possibility you could engage in a testing the water communication. The second, which I think is probably long-term going to be the best provision here, is the confidential review process, which means that you can actually submit your IPO registration statement confidentially with the SEC, and nobody needs to know that you are on file, and work through the process with the SEC staff of resolving their comments and getting ready to be in a position to actually launch your offering. You may be aware that currently an IPO process can last 3 or 4 months, even in good market conditions, because you file your registration statement, it's public, there's a 30-day waiting period until you get your comments, first round of comments from the SEC, and it can often take 2 or 3 months to resolve comments to be in a position to actually launch your offering. And you're sitting out there for a very long period of time. You've got information that competitors are interested in, and you're really very limited in terms of your ability to actually move forward or to even respond to media inquiries in a very high light. I mean, you can see what happened, for instance, in the Facebook offering. When that IPO was initially filed, actually the SEC's EDGAR system crashed for a few minutes because everybody was racing to review that right away. Now you can do that confidentially, and then 21 days before you're actually looking to launch the roadshow, you can then do a public filing, and it really shortens the period, and it also enables you to get ready to go, but not make a decision to come out into the light until it looks like market conditions will be strong, and really shortens the period that you're subject to that scrutiny. Reduced disclosure. In the IPO prospectus, if you're an emerging growth company, there's certain provisions that say you don't have to provide as much information. A lot of it relates to accounting that typically you'd have to provide 3 years of audited financial statements and an additional 2 years of unaudited, so 5-year selected period. The Jobs Act says if you're an emerging growth company, you only have to provide 2 years rather than the 3 or 3 plus 2 there, which obviously will reduce the cost of being able to do it. You may have seen there was an article in the Wall Street Journal today talking about companies who have utilized the Jobs Act provisions to date, and there actually really hasn't been a lot of movement towards reducing the number of years presented. And if you think about it for a second, it does make sense. If a company already has those financials prepared, if it's showing a positive trend line, then you've got all of your underwriters in the company who really want to put in that third year to show how much the company's growing. And if it shows not such a great trend line, then you've got lawyers like me saying, you know what, you better put in that third year because it could be misleading otherwise to be ignoring that information. So what we're seeing is unless there's a really good reason why you're not presenting that third year of audited financials, that this provision to date has not been utilized. A provision relating to executive compensation, on the other hand, very helpful. A few years ago, the SEC included additional disclosure requirements with respect to executive compensation, including the dreaded compensation discussion and analysis section, or CD&A, which can go on for 20 pages or more. It's painful to read. I assure you it's painful to write. And if you're an emerging growth company, you don't have to include one at all. So I think that you will certainly see people taking advantage of that quite significantly. And then finally, it was mentioned that there's a requirement to certify your internal controls. And if you're an emerging growth company, you do not have to have an outside attestation of your internal controls or that certification, at least for the first few years after becoming a public company. So all of those provisions very helpful. And then finally, the last thing, analyst reports. There were concerns that the restrictions imposed on having analysts come out with their research either during or following an IPO was impairing the aftermarket for IPO securities. And so what the Jobs Act did is basically take away a lot of those restrictions and said that even if you're affiliated with an underwriter, if you want to put out your research report during an IPO or immediately after an IPO, you can, and there won't be any restriction. This is one that I think so far the experience has been people are a little reluctant. Again, I think concerns about liability during a pending IPO of having a research report from an underwriter in the IPO saying how great the stock is led to some concerns, but we may see some liberalization going forward. So what are the takeaways from the on-ramp experience so far? I think it's hard to say whether these provisions have encouraged more companies to file for IPOs. There certainly have been a number of companies that have made that confidential submission. The SEC staff has advised that so far there have been over 100 companies, but of those 100, only about a third of them have actually gone forward and filed publicly and moved forward towards an IPO. Now, it may be a little difficult to determine in the short term because this year has not been great in terms of marketing for IPOs, but we will see whether more companies actually do take advantage of the provisions. I mentioned earlier one thought that I certainly had is while this is helpful for emerging growth companies, I would certainly like to see at least some of these provisions extended to larger companies as well, particularly the confidential review. I think that certainly when you get a very high-profile IPO, it is only helpful to limit the hype period before the IPO. And I can only think that perhaps the Facebook experience could have been a little bit better had they been able to file confidentially and waited until much closer to the period in time when they were actually launching their marketing, instead of having it sit out there for months and months and months and just having people continue to speculate. And then finally, while these rules are certainly helpful, you can't look at the Jobs Act in a vacuum compared to all of the other securities regulation and disclosure rules out there. And while the Jobs Act certainly has been a help in reducing disclosure requirements, there are other rules that continue to be adopted that effectively increase the cost of staying public. They legislate through disclosure, so to speak, by actually requiring companies to talk about more and more in their public filings. And a great example of this is the conflict minerals rules that were just approved by the SEC, stemming from, I will note it was not an SEC initiative, but it stemmed out of the Dodd-Frank Act and will require extensive cost for companies who do any sort of production involving certain metals, including gold and tin, to go up their supply chain, try to get certifications, have to potentially file reports that will need to be certified by independent auditors in terms of the production of the source of minerals and whether or not they origin from the Central African nations where there have been conflict. This applies not only to domestic companies, but also to foreign private issuers. And my sense is that you look at that regulation and other disclosure requirements, especially in light of the number of ways that you can avoid going public and still being able to access capital markets, I think it will be a disincentive for companies to decide to access public markets, particularly here in the United States. Thank you.
Well, it's great to be here. Venues like this are very important. Unfortunately, on this topic, for me to learn about the Jobs Act, because I've been a little bit busy with things like conflict minerals over at the SEC, which, don't worry, it'll create jobs for Joe and others. Anyway, so at this point, I should give the standard disclaimer. My remarks today are my own and don't necessarily reflect those of the Commission or other commissioners. And especially at events like this, I like to give that disclaimer with a follow-up because I'm also a minority commissioner, so I have no real authority. So anything I say, don't get too excited. So I thought I would like to set the stage here, a little bit of context, because I think the panel has expertly teed up the issues presented to the Commission by the Jobs Act. And so the presentation, though, is lacking one critical piece. How are we going to tackle this stuff at the Commission? And what's going on at the Commission? What are the priorities of the Commission? And how will this stuff, the rulemakings that are necessary to implement the Jobs Act, to give effect to the goals of Congress and the Jobs Act, how are they going to be rolled out? And so you need to take a step back and understand metrics, just simple metrics about what the Commission's up to right now. The Dodd-Frank Act, which was July 2010, was over 2,000 pages long. And to put that in context, depending on which version you get. I realize I play a little bit around with the numbers there. Compared to the Sarbanes-Oxley Act, which was 66 pages long, the Dodd-Frank Act is a tremendous amount of work for the SEC. Within the Dodd-Frank Act, the Commission has 100 mandated rulemakings, 20 plus mandated studies. And in a year, especially an election year, where you've heard a lot on the campaign trail about Dodd-Frank, Wall Street being reined in, given the title, the Wall Street Reform Act, it's simply not true. We have 70% of the rulemakings left to complete under the Dodd-Frank Act. But folks like to pay attention to the proposed rules because there was an early flurry of activity at the Commission and other agencies to issue proposed rules in an effort, a far-fetched effort, I think, to meet the intense deadlines set by Dodd-Frank, a lot of which, most of which were one-year deadlines. So by 2011, a large chunk of these rules were due. But blissfully, we've blown through a lot of those deadlines, and I really mean it, because to me, it's like missing getting in your homework. No need to get it in the next day if it's not done right. So since we've missed the deadline, I hope and expect that the Commission can take a deep breath and reprioritize, focus on things that are actually important within Dodd-Frank, which raises another issue. What in Dodd-Frank is important? There are 2,100 pages that are supposedly, purportedly responsive to the financial crisis, and admittedly some pieces are responsive at least. Whether they resolve issues seen is another question. And simply a whole slew of other provisions just aren't. And Joe's already teed up one of them. And again, I'll get back into metrics here to give you a sense of how we do things at the Commission. The conflict mineral rules were accompanied by what's called the extractive resources rules. Both of these rules, 1502, 1504 of the Dodd-Frank Act, have very laudable humanitarian goals. They have absolutely nothing to do with the SEC's mission. What do they have to do with the federal securities laws? That was the mechanism that Congress chose to drive through this reform in an effort to cure humanitarian issues completely outside the United States, not having anything to do with US investors except the burden of the cost. And so these were mandates in Dodd-Frank. They were mandated to be completed in a year. We missed that deadline, obviously, by about 13 months. The rules are now complete. As a commissioner, I've now been here back to the Commission for a year and a week. This was done, I think, in my 10th month. It took up about 20% of my time. So if you think about priorities and how we spend our time, I spent 20% of my time on those two rules. Again, very laudable in their goals, but having nothing to do with US investors, the financial crisis, and indeed nothing to do with jobs. Now, as you all know and you've heard here, in April, there was a huge bipartisan support for a Jobs Act. I think people have been, despite minor SEC bashing, which is what I get for playing cleanup here, I have to address the SEC issues. I think people have been very polite. Most of the Jobs Act could have been done by the SEC over the last 30 years in one way or the other with existing statutory authority, exemptive or otherwise. General solicitation in particular that Joanne was talking about, that's something that's been on the block for over 20 years. It's been recognized by the career staff, even folks who have more of a regulatory bent than others. This is an area where technology has really just superseded the rule set, and we needed to pay attention to it. And in fact, what folks didn't see is that prior to April, we actually had the staff prepare a concept release on general solicitation, removing the ban. Now, the debate at that time, between January and April within the Commission, was some of us wanted it to be a proposed rule, and others wanted it to be a concept release. A concept release is a precursor to a rule, less actionable, not actionable at all, quite frankly, under the APA. So that was the debate, and of course Congress came in, gave us the mandate to get rid of the ban. We thought that would have provided clarity. The deadline, as was pointed out, was in July. As we've grown accustomed to because of Dodd-Frank, we blew right by it. And all with a mind towards the end of August, issuing what we call an interim final rule, a rule that is, the judge is laughing. Hopefully it would have passed his muster, but I'll tell you, the intent was to to have a final rule in hand on which we would still get comment, but as to which there would be no confusion as to its applicability. That had been the promise. That had assuaged some of the concern amongst at least two of us as to the delay. And of course, at the last minute, like Charlie Brown with the football was pulled away. And what we ended up with was a proposal, a very good proposal substantively, but a proposal nonetheless. And as Joanne and Joe and others have talked about, we just finished our comment period on that rule, and we are already getting much agitation from various corners that portends, I think, to diminish the strength of the proposal as it came out in August. And so it's very much a question what the final rule is going to look at like. I hope it'll be done by the end of the year. It's critical for the Commission to give effect to the Jobs Act. General solicitation, I think, was the one rule that we had with the shortest time frame. It is a pretty simple statutory mandate as they go. If you took a look at it, you'd be surprised that it's this complicated. It simply isn't, but it's going to get very complicated before it's done. And at the same time, as you've heard about the discussion on crowdfunding on the House side was self-effective, which is, as I've learned now in my 1 year of pulling my hair out at the Commission on certain mandates, it's the way to go. I've encouraged every congressman I've met to not mandate rulemakings anymore because if they really want to get something done and get it done timely, replacing our rules by legislation, if they're just going to mandate that we be scriveners for them anyway, they might as well do the hard work for us. So crowdfunding is not now self-effective because at the last minute in the Senate version and within the conference, the whole paradigm of crowdfunding was completely changed. Now it's dependent on rulemaking, a rulemaking which I don't even have on my desk yet. So that 270-day deadline from April seems much in peril. And the scope of what we're going to see, too, is very much a question mark. And so it pains me to say that the priorities of the SEC right now aren't geared towards the Jobs Act. We just left our small business roundtable, our annual roundtable, where we all say nice things about small business and then get back to things like conflict minerals. And, and so you can feel warm and fuzzy about it, but if you're not in charge of the agenda, if you can't get things done on your own, which of course I can't and others can't, we can't guarantee the timeliness of the situation. So one last point as to the evolution of the bill, and Joanne said something that made my ears pop up in that oftentimes when the chairman of the SEC acts, it's reported as the Commission, the SEC, and elsewhere, especially in the press. Folks view the chairman's acts as those of the Commission. The opinions of the chairman with respect to the Jobs Act, I can tell you, diverge dramatically from at least two of us on the Commission. There was a letter sent to Jack Reed the night before the bill was passed that the chairman sent, the Commission did not. It doesn't mean a majority of the commissioners went and signed off on it. That represented views I personally disagree with, and at least one other commissioner I know does too. And that's often viewed by folks as the SEC weighing in against the Jobs Act. I can tell you there's a very vocal minority that's very for the Jobs Act, and we're trying to push to make this a higher priority on our agenda. It's not only to give effect to the congressional goal of creating jobs, but for me personally, one of the things I have a concern with is the competitiveness of the U.S. financial markets. And IPOs have been raised. Joe was talking about the market this year. Obviously, it's doing a little better in the U.S. Than the last 3 years, but if you look at IPO numbers, which I do, not because they're just an easy proxy to use, but because I personally believe they're indicative of the health of capital markets generally. For the last 3 years, we've just been absolutely getting killed on IPOs, in particular to mainland China and Hong Kong. Now, many, I think, rightfully question the quality of those issuances, and I think there's good reason to do so. However, the numbers speak for themselves, and what they're indicative of are vibrant capital markets outside the United States, outside of the EU. The New York, London debates are long gone, folks. Just look at the numbers coming out of Europe. Just look at our own numbers. Asia really is rising. The capital markets are vibrant. The IPO numbers eclipse ours. And so long as our atmosphere here is hostile to IPOs or even private funding, I think we're going to see a migration of capital and human talent there, and that would be quite a shame. And on that last point that Joe made, which was a good segue initially, that conflict minerals is going to be extremely expensive by way of disclosure. And where we take away on the IPO on-ramp, lots of burdens for emerging growth companies as they try to become public companies. As I've been saying internally, the Lord giveth and the Lord taketh away. Because in conflict minerals, we've just added an extremely expensive disclosure regime. And not only that, an audit requirement that if it takes off on a trajectory like that of 404B, which the Jobs Act specifically eliminated for a 5-year period, could result in the same net effect and cost as 404B. So anyway, looking forward to the discussion. Thanks.
There's been some talk here about difficulty in complying with deadlines. Douglas Adams, the author of The Hitchhiker's Guide to the Galaxy, was famous for not following deadlines, and he had a phrase that I think is well respected in Washington. Adams's phrase was, "I love deadlines. I love the sound they make as they go whizzing by." Our 5 speakers all address different aspects of the Jobs Act, and I'll refrain from talking about the parallel to describing an elephant. I will offer each of them a brief, and I emphasize brief, opportunity for a second round in which they may have a word or two to say about an aspect of the Jobs Act that somebody else talked about. And then I want to reserve time, which we have about 40 minutes as of now, for questions from the floor. So, Professor Miller.
So I guess I'll stay on the topic of deadlines whizzing by. I said that WeFunder is up in beta, meaning that they are accepting pledges to invest, but of course they can't actually accept any real investments until those regulations implementing the Jobs Act come out. Implementing the crowdfunding sections come out. That's due for January. Now it looks like that's not going to happen. I'm not too surprised, but you're going to have a lot of disappointed 20-somethings, Commissioner.
Well, what I'd like to say, and actually I went to a roundtable at Stanford soon after the act was passed, and I realized that the Silicon Valley had actually gotten together and done a lot of the drafting in the IPO on-ramp. And their lawyers, their counsel was very smart to make it self-effectuating. And I agree with Commissioner Gallagher, is that I think the future, if I were to be asking Congress for something and asking the SEC or my old agency, the CFTC, to change something, I would probably make it self-effectuating. I think that's probably the way to go. As much as Congress likes to defer to the expert agency, sometimes if they've already made up their mind what they want the agency to do, they should just do it.
Apart from the self-effectuating part, Congress put into the Jobs Act any number of things that the SEC has to do that will cost money. Crowdfunding has a large number of regulations, including the portal requirement, including a requirement about disclosure and even about audit that Robert mentioned. They put into crowdfunding a large number of regulations. A+, which we haven't talked about, has a large number of regulations. Those are put in by Congress. Conflict minerals, which is a terrible rule from a securities professor standpoint, was put in by Congress. The SEC's not doing this, and so the SEC gets a lot of grief. But all of what we're talking about, including the delayed deadline, came from Congress, not from the SEC dragging its feet. So we have to push. We have to take that into account and recognize that there's always a balance, and the regulation that's required came in large measure from Congress.
A lot of the focus of the Jobs Act and what we talked about here is on equity securities, but as people well know, that there's another part of the capital balance sheet, which is debt. And I just wanted to take a minute and talk about how this Jobs Act may continue to impact the debt capital markets, which are a very important part of our job as securities lawyers as well. In particular, because of the loosening of the restrictions regarding the number of securities holders and being able to stay as a private company, in addition to the increased burden of becoming a public company on the disclosure front, we're continuing to see more and more large bond offerings that have moved from what used to be called 144A, which is a securities exemption that would have back-end registration rights. So basically you sold to large institutions and then conducted a back-end exchange offer, which wound up on having that debt registered and having the company being public, to what's now referred to as 144A for life, which means that you sell to institutions. They can only resell usually to institutions, but you never actually go that next step and have the company be a reporting company. And what's been interesting in the last 5 years, and I think is accelerated as a result of the Jobs Act, is more and more companies who are really pushing and even willing to pay a slightly higher interest rate to incur debt on a 144A for life basis, so as not to have to deal with conflict minerals and the other disclosure regulations and the costs related to them.
Just to jump on 2 points I heard on the other side of the panel, which are the expertness and independence of the SEC, two very important things for all of us. I mean, for many of us, you might scratch your head trying to figure out what independent agencies really are. Some might question their constitutionality, but that's been done years ago, and so this is what we have. And in a situation where you have 100 mandated rulemakings under the Dodd-Frank Act, where you have several, I don't know the exact number under Jobs Act, you really do have to start questioning the role of the independent agency and whether the agency is really independent. Where, where is the expertness if the mandates go 9/10 of the way? And what is the role of the agency in influencing the legislation? Why did the SEC end up with 1502 and 1504 in Dodd-Frank if it has no place in the federal securities laws? Why didn't the SEC tend its own garden, its own rule book, giving rise to the Jobs Act to fend off and to bring in-house the ability to change these rules in the way that the expert staff and the commissioners thought best suited? So I'll throw that out with one little a positive point, because I think I've been a downer, is that the 20-year-olds are there and they're alive, and they were in my office yesterday, about 8 of them, and they're ready to roll. They are, and they have these platforms. They just need the funding, whereas when I read Title III, I thought it's over. There goes the game. I think they're still going to make a go of it. It's fantastic to see that spirit is alive and well.
Thank you very much. We have 30 minutes for questions from the floor. I hope we have somebody with a mic. Yes, we do, in the back. Let's see. Anybody who wants to ask a question, we don't have a mic stand, do we?
Yeah.
Do we? We have a mic stand in the middle? Okay. Go to the mic stand, and when your time comes, ask a question. Now, I know that seems strange, but I hope whatever you do will be in the form of a question, and we'll have a reasonable end to bring it back to the panel for answers. Just tell us who you are. I'm going to have a hard time seeing you because there are pretty bright lights up here. So, yes, please.
Well, I'm a little intimidated by that preface, but I'll do my best. My name is Bonnie Wachtel, and I'm the CEO of Wachtel & Co. Inc., which is a small broker-dealer here in Washington, D.C. Quick comment, then a question to Commissioner Gallagher. So delighted to see you here. Let me posit, by the way, that the avalanche of new regulation, really a reign of terror in the brokerage industry, is part of the reason why you see financing down through traditional venues and why Congress is so desperate to go to non-traditional sources. That's the comment. All right, from what I read about the Jobs Act, at least crowdfunding from industry stuff, is that the states have decided they're ready with a campaign of massive resistance, because if this is going to go forward, basically it makes you wonder why we've got half of the securities regulation on the books and everything else that they do. However, I do think that when you look at the thoughts of Mary Shapiro and people that have spent a lot of time in securities regulation, what they're really looking at is, you know, most ordinary people do not make money investing in risky situations. And we've seen that in the internet bubble and other bubbles. You know, the only thing they want to invest in is stuff that's all hyped and they get all excited. And I think that's part of what they're concerned about, is this is an experiment that's going to blow up and be even worse for the capital markets. They really want suitability. They want an intermediary that will look at suitability. That's my read. I wonder if anybody could speak to this from the standpoint, a little more of that concern about investor behavior.
Can I take it? Well, it's great to hear from you. Nice to know small broker-dealer CEOs are attending these events. It's great. And just think if Dodd-Frank had actually paid attention to your industry, you'd be in real trouble. You'd have that in addition to everything else. You guys got out relatively clean. Yeah, no, me neither. So, you know, I think that there's sometimes confusion between the notions of investor protection and risk-taking, right? That there's, quite frankly, an anti-state instinct at the Commission to protect investors by depriving them of choice. And I think that you're seeing that come out with respect to crowdfunding in particular. You know, I was reading a statistic in a Forbes article earlier today that $145 billion a year in lottery tickets are sold. Do the math on the chances of hitting it big there versus investing in markets, right? Including $50,000, $100,000 a time in crowdfunding. And so I do think you're right. I think that generally speaking, regulators are well-intended. They're the government and they're there to help. But the problem is, in this quest to help, so often, in particular with respect to retail investors, that means we're here to deprive you of choices. We're here to de-risk the capital markets for you because you can never understand it, and that's a big problem.
Yeah, one comment on the crowdfunding. I just divided the amount of money that WeFunder has already had pledged, about $28 million, by the number of projects involved in that, about 150. So you're talking roughly $20,000 per project. These are really small projects, right? If you look at the fraud rate on what might be occurring there, right? If the fraud rate went above 1%, this market would clearly collapse. You can't tolerate a fraud rate that big. So if you are something like WeFunder, here's a prediction for how your business model is going to work out. It's going to work out like eBay. eBay is in the same kind of business. They make a market between people who want to buy and people who want to sell. And the way eBay works now is eBay insures people on eBay against fraud. If you're ultimately defrauded on eBay, eBay returns your money and eBay takes it up with the fraudulent seller. So prediction, once crowdfunding actually gets going, you'll have large numbers of transactions with a very small fraud rate and small amounts of money at issue in any particular securities issue. I bet the funding portal assumes the fraud risk and will protect the market against fraud. If someone commits fraud on the crowdfunding site, I bet WeFunder will ultimately return their money. Right? They won't ensure the investment prospers, but they will insure you against the fraud risk.
Just to point out, the losses will not be coming from fraud. You don't need fraud.
Right. No, that's very true.
Hi, my name is Ben Pugh. I'm from Orange County, California, the state where all business is fleeing from. I just had a quick question. In this new regime of lots of small businesses raising lots of small capital with no disclosure requirements, presumably no regulation FD, where do prohibitions on insider trading fit into this smaller paradigm, or are we going to have any prohibitions on insider trading on these secondary markets that are sure to develop outside the main stock markets, their main exchanges at this point? Or is that something that Mr. Gallagher is going to work on when he's done with his conflict minerals rulemaking?
Nothing has to be done. Insider trading rules will remain as they are. 10b-5 is not changed. Insider trading is not changed. It applies to any purchase and sale of securities, and it will apply to the small as well as the big.
Though perhaps I should add, since very few people in the securities area seem to be taking this up, when the Supreme Court in O'Hagan sustained the approach to inside trading, the prevailing approach to inside trading, they did it as a matter of property rights. That is, of enforcing people's rights in information. And that implies that any company that wanted to raise its hand and say, we're allocating rights in information to our insiders and they're perfectly free to trade, under O'Hagan is perfectly free to do that. The interesting question is, what will companies do? In a world of vibrant competition, you would expect to see some companies authorize their insiders to make their money by inside trading, while other companies are paying them salaries and bonuses. It will be very interesting to see what develops in young, new markets.
You know, I've noticed a lot of focus on disclosure, and people talking about the fact that you will not be making, or these issuers will not be making certain disclosures. I mean, if you look at all the behavioral finance literature, what you'll find is nobody reads them. So what it becomes is a liability document when something goes wrong, and then your lawyer reads them and tells you what you missed. So, you know, I'm less worried and less concerned about these changes that result in less disclosure, because I really think it's become a rote exercise, and you'll find the same disclosures in virtually, you know, risk factors, for example, become more and more identical. So I'm not that worried about less disclosure that we're going to see out of the Jobs Act, because I question its usefulness today. Speaking for myself and not my company.
Right. Those of you who know that I do tend to be interested in the Chicago approach to economics also may remember that one of the things that is generally done in thinking about financial markets is to distinguish thickly traded markets from thinly traded markets. In thickly traded markets, where there's a lot of liquidity and there are a lot of traders, it just doesn't matter whether any investor reads the papers. All that matters is that 2 or 3 professional investors know what's going on. You trade, and all the amateurs get the same price as the pros get when they trade among themselves, and that process protects the amateurs. In a market with only amateurs, and that's one of the possibilities that's being set up by the Jobs Act, that we'll have very thinly traded markets with only amateurs. Those are the markets where the lack of professionals to mediate this information and set a price that the amateurs get is most important. And again, we're running an experiment. All life is an experiment. But one common prediction is that the price in these markets will be not dominated by fraud, but simply less accurate generically than the price in the large and thickly traded markets. Yes?
Hi, my name is Julie Axelrod, and I'm currently a nonprofit lawyer in DC, but I used to be a corporate attorney in California. I'm one of the people who fled the state because of bad business climate. But my question is about the new rules that make it more attractive and possible not to be a public company, even if you have 2,000 shareholders, and just the speculation that a lot of companies won't be public. And the other side of this is that do any of you see the public being frozen out from making money in the markets, and it's sort of becoming something that only sophisticated people have the opportunity to do? Or do you think I'm just worried for nothing about that?
I can't resist again. I'll jump in real fast. I think it's sort of picking up on the last thought in response to the first question of, you know, the intent often coming from the government, especially the SEC, and implementing the Jobs Act mandates is a good one. It's an investor protection. Who can argue against it? But the net result of it oftentimes is a reduction in choice, right? One of the best ways to help protect investors is to allow them the opportunity to choose how to put their capital at risk and to succeed or fail. And in lieu of fraud, that should be the types of markets that we want to have. And unfortunately, to the extent that becoming a public company, despite the best efforts of Title I of the Jobs Act, is too much for companies, and because we've hedged nicely by making it easier to stay a private company, what we've done is to say, yes, for those investors who have a certain level of sophistication, however artificially we define that, they have all of these wonderful opportunities. Everyone else, go compete with all these high-speed trading firms on the New York Stock Exchange and see how you do. And I think that that's not the choice set we want to provide to investors. I think there is a real risk of that, picking up on part 2 of your question.
Yeah, that was the only question, just whether this is a risk that will have sort of
It's a huge risk.
freeze out people, regular people.
Well, and just think about what's going on right now, especially right now. 0% interest rate environment, which, as we learned yesterday, might be extended to eternity, given the way the jobs numbers came in today, right? If the Fed's going to tie it to the unemployment rate. Investors, retirees in particular, chasing yield wherever they can find it. You can't find it necessarily in the equities markets right now. Where are they chasing it? High yield bonds, structured products, other things that are unfairly setting investors up, I think, to fail, especially at the worst time of their life, during retirement. When in fact we haven't gotten crowdfunding rules out that, Lord knows, today's crowdfunding startup could be tomorrow's Zynga or Facebook, or Lord knows when, and that person can retire a wealthy person. So it's a real risk. It's something to pay attention to.
One of the great things about the American market over time is compared to Europe and actually Asia generically is that it's very democratic. It has a greater spread of investors among all economic classes, has over time, and we are losing some of that. So how might we respond? In an article that I've done with my colleague Don Langford, we suggest that the time has come to have 2 levels of publicness. One level of publicness would be with reduced regulation, which would be the traditional disclosure, 10Ks, 10Qs in a financial sense. And then a second level that would have a much higher breakpoint that would apply for those firms for which we have non-investor concerns. I mean, one thing that came out of the financial crisis was we had systemic risk. We had externalization of big firms putting burdens on society to make us pay for their errors. I think Convict Mineral ends up in that bucket. But in any event, if we went to a 2-tiered level, we could be more responsive and lose some of the diminution that we've had in the last few years, in the last 2 rounds of reform.
Hi, Rachel Perez. I'm with the New York Lawyers Chapter. I think interestingly, just to note, that people have been mentioning that it's unsophisticated people that are involved here. When the accredited investor standard basically puts the people that can participate in these 2,000-person offerings like in the 1%, according to like the Obama administration's estimation of what makes you in the 1%. It's completely unrelated to my question, but I apologize. My question is very pointed to Mr. Gallagher, and just asking someone in the commission who's involved with the rulemaking, where do you see the intersection between the general solicitation rules and with the CFTC, one of the prongs of being exempt from being a registered commodity trading advisor by not holding yourself out to the public as a commodity trading advisor, and how those allowing general solicitations could then kind of get you into the CFTC's regime, obviously if you trade in commodities and futures and things.
Well, the good news is you don't have to worry about it because Gary Gensler's already taken care of that by rolling out CFTC regulation to a wide pool of investment advisors already in their Rule 4.5, which I'm sure Joanne, having been general counsel over there has followed. And so basically,
This is actually a fallout of Dodd-Frank, right? Because traditionally, one thought one was a commodity trading advisor when you talked about investing in commodities, and even to a certain extent, commodity futures. And all of you in the room probably think you know what that is, which is, you know, gold, silver, oil, wheat, whatever. But when Dodd-Frank decided to redefine commodity interest to include swaps, and the arm wrestling went advantage to the CFTC, so almost everything is within the CFTC's jurisdiction, very little left with the SEC. All of a sudden, you have a lot of entities who never thought what they were holding themselves out as doing had anything to do with commodity interests, and pleas of various parts of the industry to the CFTC to at least modify some of their regulations in this regard are falling on very deaf ears. And so, in fact, although we've been talking about the burdens that the SEC has been directed by Congress to impose on the financial industry, actually the bigger burdens, in my view, are going to come from the CFTC. And I'm not in private practice anymore, so I don't have to sell my time, but I will tell you that a lot of people are very surprised to find that their particular thing that they do is now subject to an agency that they've never heard of. So it's just part of the pendulum swing that we saw as a result of the financial crisis.
so, and I think just to close it out, I mean, it may be that there's a limited pool of folks who wouldn't otherwise have been affected by the Dodd-Frank changes that now, because of general solicitation and their activities in the future space, might pique the interest of the CFTC. But I think the slice will be pretty narrow now, given the fact that the CFTC has already invaded this space in a big way. I'll note also
There's a pending litigation.
that's what I was going to note, Joanne.
There's hope.
That the judiciary might come to the rescue here. All of our faith is in the judiciary.
We can make the rules even more complicated.
or you can make them go away, Judge. Yeah.
I don't see anybody at the mic. Any further questions out here? Well, any further exchanges on the panel? Any closing comments?
You're right, there have been any number of waves back and forth the last 4 or 5 decades. HCA has gone public and gone private several times, both directions. Burger King just went public after being private. If you look at, it goes back to just to tie up to a closing comment in terms of, did the Jobs Act produce jobs? I mean, ultimately, that's the policy question we ought to ask. Now, the sub-point was, well, did it produce more IPOs? Because certainly Silicon Valley cared about that, and I think many people cared about, did it produce more jobs? Well, it's early, as Joe said. This is not a great year for it, but we need to ask, do we have more IPOs that are producing jobs? What have we had? We had Manchester United and its soccer business. Is that producing jobs? I don't think so. And so knowing what produces jobs is hard as heck. I mean, it's not an easy thing to do, and so we got to take our best shot. But we don't know whether it has or not. But the difference in the 1970s is that we have we have had a financial revolution, and part of it's connected to commodities and futures and derivatives and technology and computers. We trade things a lot different, and so it is possible. There are new marketing avenues that we can do, that we can raise money in different ways. But raising money in different ways just means different problems. One of the, I mean, I'm not a commodities person, but one of the things that has surprised me, who's doing physical commodities trading? Well, it turns out that Morgan Stanley has a big business in
The Wall Street refiners.
the Wall Street refiners, Goldman Sachs, J.P. Morgan Chase.
But there is provisions that in the Dodd-Frank Act which are going to change that too. They just haven't gotten around to doing the rules on them.
So this is a different world, and it's constantly changing. I think, I mean, I teach budding lawyers every day, but what I tell them is that technology and changes in market creates new space. And a lawyer who's successful is someone who occupies that new space, and perhaps more pejoratively, who can elbow Commissioner Gallagher and his associates out of that space and says, this is deregulated space. So there's this constant push between technology generating new innovation in space and private parties wanting to occupy that space, and the regulators saying, wait a minute, this is just doing the same thing we've been doing, we got to adapt, and it goes back and forth, and that's why it's good for all of us in a sense, but that's why it's so hard to figure out what the right solution is.
And if we don't get the solution right on either regulation or deregulation, the brain-powered helicopter will take all the deals to Hong Kong or Frankfurt.
If I could add something, because I work with a lot of companies who do going private transactions and then take companies public again. I think that there will be, to the extent that financing is available, there will be additional incentives as a result of the cost of being a public company to deciding to go private. One of the things that will be weighed into the modeling is if you have a certain amount of cost that you're going to have to expend every year with respect to having to comply with these regulations, if there's either a management group or a private equity group is looking to take a company private, it certainly will be one of the things they'll model in terms of being able to improve the returns on the margins. On the other hand, with the larger of these companies, you certainly have to be able to finance that buyout. And it goes back to the comment I made about 144A for life. It used to be that with these larger buyouts, by all means, you would continue to be an SEC registration because that helped with respect to the debt financing. Now I think a lot of companies are just going to say, we don't want it. It's just too much of a burden, and at least while we're private on the equity side, we'll provide bondholders on the side with audited financial statements, but we want nothing to do with conflict minerals. We want nothing to do with compensation discussion and analysis. And by the way, the bondholders want nothing to do with those things either. I do think that eventually those companies do need to go public again at some point, or they get sold to other companies within their industry. But when we take the step back and think, never before have we had so much technology available for ordinary investors to be able to access information about companies and to have access to capital markets. Yet we have rules that are in effect that are basically encouraging people not to be able to put those things together. It's really unfortunate. I would hope that it's something that the SEC would be thinking about in their ongoing rulemaking.
Any final comments on the panel? Please join me in thanking our speakers.